welcome. It's lovely to see you again. For those new faces, welcome also. My name is Mervyn Vermeulen. I'm an attorney, and I will be presenting this webinar today with assistance from Lee Govender. Lee is one of the attorneys at my firm. She spends quite a lot of time in the trenches, as it were, so she's going to take us through the ins and outs of the actual practice of maintenance litigation, in specifically the maintenance court, whilst I'm going to be looking at some of the more theoretical parts of maintenance and maintenance litigation. Right, so when a fellow says it ain't the money, but the principle of the thing, it's the money. And there's nowhere in litigation where this is more apparent than with maintenance. It is a court in general where fights are fought very bitterly, and fights are fought over a very long period of time. It is a contentious subject. I see that we've got quite a lot of mediators in with us today, and that's a wonderful thing to see, because I think especially in maintenance, there is much scope for good to be done by mediators. The reality is maintenance litigation is acrimonious, it is time consuming, and it is extremely frustrating considering the backlogs of the courts. So unfortunately, I must confess that maintenance litigation is something which is probably not going to go away in the short term. There are matters that cannot be mediated, that need to go ahead by means of litigation, and I'm sure Lee will share with you a matter that she dealt with recently for spousal maintenance, which had to go all the way through the maintenance court and seemingly is now being taken on appeal to the High Court from the maintenance court, but I'll leave that to Lee to share with you. Just some house rules for today's session, and just up front, we are going to be recording the session today, so if anyone does not want their smiling face to be on the recording, you are welcome to switch off your camera. We're obviously going to endeavor not to disclose any personal information to third parties, but we do find it is useful to have a recording to distribute to attendees or people who could not make it into the session today. I will, however, be spotlighting myself, so you should not see yourself too much on the recordings. So just house rules and etiquette today. Please use your real name for registered purposes. If you have any comments and verbal questions, please keep them for the time slots provided. I assure you, in all of our webinars, we do make much provision for discussion at the end of the sessions. If you want to ask a question or make a comment, please use the raise hand function. I'm sure all of us know how to use that in the era of COVID and the rise of Microsoft Teams and Zoom et al. Please feel free to type questions or comments in the chat box at any time. If it is something germane to the topic that we are busy with at that stage, we will deal with it as and when it arises. If it is something that needs to wait for a little bit later, we will obviously deal with it in due course as and when appropriate. Respectful discussion, dissent and comments are welcomed. All of us here today are family law professionals in one capacity or another, and we all have information that is of use to one another. Please, however, keep it respectful. Please avoid hate speech, victimization, or belittling attendees. As I said, we are all here to learn. Neither Lee or I profess to know everything. However, we are attorneys in active practice, so hopefully we will be able to give you guys some valuable information today, and also receive valuable information from everyone in attendance. As I mentioned, we are going to be recording this session. Portions of it will be distributed free of charge. Please, however, do not record or distribute our content. As many of you know, we do make a habit of doing quite a lot of these webinars, and it only remains possible for us to do so if we are able to have the knowledge and the security that our IP is not being distributed unlawfully out there. Right, so without further ado, let's get into the content. The sessions today, or the session today, is going to be split into three portions. Number one, I'm going to be dealing with the substantive law framework regarding maintenance. We're going to be looking at maintenance for minor children. We're going to be looking at maintenance for major dependent children. And then finally, we're going to be looking at the very, very bitter end, quite appropriately, at the issue of spousal maintenance. Thereafter, Lee is going to be looking at the maintenance court and the maintenance litigation process from a practical point of view. And then finally, we are going to be dealing with two very, very practical aspects. Number one is going to be in terms of international maintenance claims. What is the legislative framework? How do we deal with international maintenance claims? And then finally, we're going to look at Rule 43 and Rule 58. To those who are comfortable doing so, please feel free to use the chat bar to inform the remainder of the attendees who you are, what you do, what your contact details are. Obviously, with COVID, our ability to network in person has been diminished quite severely, and I do welcome anyone who would like to distribute their contact details to attendees. It is not compulsory, only if you feel comfortable doing so. All right, so the majority of maintenance disputes, in my experience, revolves around minor children. Obviously, these can take various forms. It can take the form of maintenance claims in the context of divorce proceedings, and it can also take the form of maintenance outside of divorce proceedings. For example, unmarried parents, parents who are already divorced, who are going through a dispute. But the lion's share of maintenance that we really deal with in practice revolves around minor children. Now, the concept of maintenance for minor children can be found in the Children's Act, and specifically Section 18(2), very ironically, not necessarily in the Maintenance Act. It is one of our 4 pillars of parental responsibilities and rights. And Section 18(2) reads, and I just give the relevant sections: the parental responsibilities and rights that a person may have in respect of a child include the responsibility and the right to contribute to the maintenance of the child. Unfortunately, and very ironically and strangely, the Children's Act does not give a proper definition of what constitutes maintenance. What is the definition? What does this term maintenance entail? The Children's Act gives us a very good definition of contact. It gives us a very good definition, in fact, of care. And under Section 18(3), it gives us a nice definition of guardianship. It does not, however, give us a definition of maintenance. For that, we need to go and do a bit of a deep dig, and we can find some allusion to what maintenance is in Section 15(2) of the Maintenance Act. Ironically, not in the definitions of the Maintenance Act. And what Section 15(2) says is, the duty of support extends to such support as a child reasonably requires for his or her proper living and upbringing, and includes the provision of food, clothing, accommodation, medical care, and education. This is obviously not an exhaustive list. I'm sure most of you who are present today are able, just off the top of your head, to identify various other portions of what a child could reasonably require for their proper living and upbringing. So we deal with the basics: food, clothing, accommodation, medical care, and education. And then obviously it extends to what we can really call undisclosed and undefined further areas, which I'm sure we can all envisage. Now, if we go back to this section here, and I'm going to try and use my on-screen pen, I've realized that sometimes it works for some attendees, for some it doesn't. So I'm going to draw on screen. Those of you who can't see it, please do forgive me. It is a bit of an idiosyncratic thing that Teams does from time to time, but I've highlighted or just drew a block over the word reasonably. What is constituted by reasonable? And this is really a question that we very frequently get in practice, not only from clients, but also from family law professionals. I'm very often asked, what is the formula? How do you calculate what reasonable maintenance is? And I can tell you that my answer really tends to make quite a lot of people quite upset, and it is, how long is a piece of string? What is reasonable? And the reason I say that is because that really is what the Act says. If we look at section 15.3 of the Maintenance Act, this is very descriptive of what the Maintenance Court does when conducting a maintenance inquiry, and it gives us good insight into what the Maintenance Court actually looks at when adjudicating a maintenance dispute. And it reads as follows: without derogating from the law relating to the support of children, the Maintenance Court shall, in determining the amount to be paid as maintenance in respect of a child, take into consideration. Very important. Before we even go into the three factors, I want to highlight the words take into consideration. These already imply a discretionary element in terms of the court. The court must take it into consideration. The court is not necessarily bound by it. Furthermore, the Act also does not say that you must give more weight or less weight to a particular one of these three factors. Now, what are the three factors? That the duty of supporting a child is an obligation which the parents have incurred jointly. 2, that the parents' respective shares of such obligation are apportioned between them according to their respective means. And 3, that the duty exists irrespective of whether a child is born in or out of wedlock or is born of a first or subsequent marriage. So this is what the court must take into consideration. Really, 2 is the meat of it, apportioned between the parents according to their respective means. Now, this section B, if I can take the discretionary element of the court even further, if we can draw a nice block around it. Any amount so determined shall be such amount as the Maintenance Court may consider fair in all the circumstances of the case. In other words, maintenance is a factual question based on the unique identifying characteristics of each particular case. In summary, one size simply does not fit all. The Maintenance Court may make an order which is what it considers fair in all the circumstances of the case. One cannot overemphasize the measure to which a maintenance court has a discretion in this regard. Now, please use this as a backdrop for the remainder of our discussion going forward. Now, let's look at the three-pronged approach in terms of how maintenance courts really look at these things. And I think in terms of any maintenance adjudication, this really is what we need to look at. Number one, step one, the need. What are the reasonable needs of the child? Now, in terms of identifying the reasonable needs of the child, obviously, we are going to consider the unique characteristics of every case. However, if we go back to section 15.2, my apologies, we know that our starting block is going to be what the child reasonably requires for his or her proper living and upbringing, which includes food, clothing, accommodation, medical care, and education. So that's going to be our starting block. And we need to see what is reasonable under the circumstances. And what is reasonable under the circumstances really is a factual question based on the circumstances of the child at that point in time, also historically. We are blessed and cursed in South Africa to be living in a very heterogeneous, diverse society. And that disparity in terms of personal circumstances is very, very apparent if one looks at wealth gaps. In South Africa, we have from the poorest of the poor to the richest of the rich. And maintenance courts, unfortunately, have a very unenviable job to have to adjudicate on matters for the poorest of the poor to the richest of the rich. What is reasonable for a child? Well, it depends on the circumstances. Is it necessary for every child to go to a private school? Obviously not. However, if the child is, for argument's sake, 13 years old, has attended private school since grade R or grade triple R or quadruple R or how many R's ever we want to fit in these days, and all of a sudden a divorce takes place or there is some sort of dispute that arises, is it then reasonable to move that child to a public school? Well, yes or no. What are the circumstances at that stage? Do the parents still have the requisite funds to keep the child in a private school, or do finances dictate? Is it on a whim of a parent? Is it a case that the child is not fitting in at a private school? What are the views of the child? Where does the child want to go to school? So the need in and of itself, as I'm sure you can all appreciate, is already an extremely subjective and case-specific aspect. Once the need has been established, we look at the means. Now, if I can go back to section 15.3, if we look at A, Roman numeral 2, that the parents' respective shares of such obligations are apportioned between them according to their respective means. Now, means, once again, ladies and gentlemen, is a very, very broad term. It does not refer to wealth. It does not refer to income. It does not refer to net asset value. It does not refer to net liabilities or net expenses. It refers to a holistic view of what is this parent capable of offering the child. A very good example of that is in maintenance cases where a parent may, for some reason, due to an accident or ill health, not ever be able to work anymore. However, that parent might sit with a 10 million rand investment or an RAF claim that's paid out, whether it's in a trust or curatorship or whatever the case may be. That parent still has a maintenance liability towards the child. So means is in the broadest sense. And if you look at my first bullet point, it means net monthly income from all sources, not just salary. It could be rentals, it could be subsidies from the state, it could be all sorts of different things, as well as assets and savings. Then furthermore, monthly commitments and liabilities must be taken into account. Now, as we've seen in terms of section 15.3, there is usually some form of apportionment between the parties, dependent on their means. Now, 90% of the litigation, which Lee will touch on a little bit later, in terms of maintenance court, is concerned with the means. Parents generally, in fighting maintenance issues, let's put it that way, in court, will touch on a couple of things. In terms of the child's needs, they would generally have a look at things like schools. The contributing parent would very often say, but this child is in a private school, we cannot afford it, we need to scale down, or the medical aid is too lavish, or there are too many extramurals. However, most parents, and I say this very carefully, most parents with big inverted commas are fairly loath to try and take away from their child. Where the big fight usually comes in is on the means. Parents would say, well, you earn more than I do. Yes, but I earn more than you do, but my expenses are more. Well, that's because you drive a more expensive car. You need to drive an Opel Corsa, whereas you are now driving a Mercedes-Benz. And these types of fights and how shall I put it, quarrels are big features of maintenance court trials. Now, once the court has gone through all of this, the court makes an order, and this is where the court is placed in an incredibly unenviable position. It must make an order it considers fair, having regard to all circumstances of the case. And that is once again from legislation. The Maintenance Act says, any amount so determined shall be such amount as the maintenance court may consider fair in all the circumstances of the case. This is an incredibly wide discretion given to the court, and I know I've emphasized it a number of times already, but it bears repeating. The maintenance court has an extremely wide discretion, and what has happened in practice as a result of that extremely wide discretion and the big caseload is that we're seeing rules of thumb that have been implemented by maintenance officers and practitioners. What is reasonable, how much is reasonable per child per month, 2,000 is reasonable, 5,000 is lavish. Well, in my opinion, one can't really say that. But in practice, we do see it happening from time to time that people work in absolutes. Right. Before we go on to maintenance for major dependent children, we've got 5 minutes. Any questions, comments, queries? I would love to hear from any of our colleagues in active practice. What are your experiences in terms of quarrels in respect of maintenance for minor children? Quiet group today, must be the rain. If anyone thinks of anything, please do alert me or just put your hand up. Great. So that takes care of the basic framework of maintenance for minor children. Maintenance for minor children is based in Vicky, I love it. It ends badly. Well said, well said. So maintenance for minor children is rooted in legislation. It's rooted in Section 18(2) of the Children's Act, which goes on further to Section 15(2) of the Maintenance Act. Alfred, very warm welcome. It's always great to see you. So please bear that in mind, folks. Maintenance for minor children has its root in legislation, in case law. And when dealing with maintenance for minor children, you always start at the Maintenance Act. It gives a very robust framework. Obviously, the Maintenance Act is rooted in the Children's Act and vice versa. Section 18(2) imposes the obligation. Section 15 really sets out what the obligation is. Section 15(2), what is the duty of support in respect of minor children? All right, lest we run out of time, let's move on to maintenance for major dependent children. We are faced with a dilemma when children reach the age of 18, or they achieve the age of majority, or the status of a major before they reach the age of 18 for whatever reason. And that is this. Section 18(2) of the Children's Act says that parents having parental responsibilities and rights must contribute to the maintenance of the child. Now, obviously, child, in terms of the Children's Court definition, refers to a child under 18, or a minor child, as it were. The problem then arises where at a later stage, the child reaches the age of 18. Now they are a major. There is no more legislative framework saying mom and dad need to maintain the child. In reality, in practice, however, we know that many children pursue tertiary education by means of university, by means of college, by means of a gap year in Thailand, or whatever the case may be, although I suppose gap years with COVID are really becoming more a thing of the past. But these children are not necessarily self-sustaining. The problem then arises that there is no legislative framework to impose the obligation. Therefore, in terms of maintenance for major dependent children, we are forced to look at the common law. Now, I'll pause here, and please, the attorneys in the audience today, please do forgive me. I would like to just very briefly explain to the other attendees the difference between common law and legislation. And it's simply this: an act of parliament. Legislation is an act: the Children's Act, the Domestic Violence Act, the Divorce Act, the Maintenance Act, the Matrimonial Property Act. These are all legislation. Nice, clean paragraphs saying these are the requirements by law. Common law refers to the courts. In general, when you hear the term common law, think of case law. Think of the courts, think of the way that the courts have interpreted it, have interpreted other laws, if I can put it that way. Now, what we must understand, in South Africa, we have lower courts, magistrates' courts, and we have superior courts: High Court, Supreme Court of Appeal, Constitutional Court, in that order. High Court at the bottom, SCA, and then Constitutional Court. Much of our prevailing case law in terms of family law comes from the SCA because it is a very, very wide application. And remember, the Constitutional Court only deals with constitutional matters. So very often family matters are not constitutional matters. So it stops at the SCA. So when it comes to maintenance for major dependent children, we look at the concept of common law. What do the courts say? And generally, we would look to the High Court and we would look to the SCA. We have a beautiful case from 1999, Bersey versus Bersey and another. For those who would like to take down the citation, 1999, 3 SA 33, and it was an SCA decision. And the gist of it is the following. And I read from the judgment itself. According to our common law, both divorced parents have a duty to maintain a child of the dissolved marriage. The incidence of this duty in respect of each parent depends upon their relative means and circumstances and the needs of the child from time to time. And I've put this in bold. The duty does not terminate when the child reaches a particular age, but continues after majority. Now, if we look at how the Supreme Court of Appeal considered this question in Bersey, I'd like to draw your attention to the parallel. If we look at, for example, they talk about the relative means and circumstances and the needs of the child from time to time. If we tie it back to section 15.3 of the Maintenance Act. Now, please be aware, folks, 15.3 talks about the support of children. So it's not applicable. I am merely alerting you to the similarities. Look at the terminology in Bersey, means and circumstances and the needs of the child. If you juxtapose this to section 15.3, everything fits in. We look at their means, we look at the circumstances, it all fits together beautifully, right? So let's go into our steps. The steps for adjudication of major dependent children has one additional step to minors. Step 1 for minors is let's establish what are the needs. It is a given. You must pay maintenance for a minor child. Why? Because the law says so. Full stop. We have 2 acts of parliament that we need to rely on here. Children's Act says as a parent, you must maintain. 15.2 of the Maintenance Act says, what is it to maintain? Look at their reasonable living expenses. If I can go back to that slide, if you'll please bear with me. Proper living and upbringing. Now, when we look at major dependent children, we don't have an act of parliament that says this is an obligation, full stop. We have to look to the common law. And Bersey, which was being certainly not the only case that deals with it, is a nice case to refer to because it is Supreme Court of Appeal and therefore a fairly universal application. Therefore, we have this extra step. Step 1, is the child a major dependent child? And this is a simple factual determination. Is the child self-supporting? In other words, you cannot run to maintenance court for maintenance for a child who is working. I might be a spring chicken, ladies and gentlemen, but if I run to the maintenance court seeking maintenance for myself from my elderly parents, the maintenance court will not be very impressed with me because I am self-supporting. This is determination number 1. Determination number 2 then follows. What are the reasonable needs? What are the further items which may be reasonably necessary? Then we look at the means. Remember what Bersey says, means and the circumstances and the needs. of the child, or the relative means. Let's not misquote the case. Right, then section 15.3b gives a maintenance court when dealing with children. Just to clarify this slide, once again, 15.3b is not applicable to major dependent children. I've just drawn the parallel in order for everyone to understand it fairly easily. Right. Any questions on maintenance for major dependent children? Please do not be shy. No hands. All right. Excellent. Let's move on to the next portion. Now, this is the one where the sparks fly. So we've now dealt with maintenance for minor children, major dependent children, which leaves only spousal maintenance, where parents are still inclined to pay maintenance for their children, even though they cross with their ex-spouse. This is something that most divorcing parties are not very keen on doing at all. Spousal maintenance, ladies and gentlemen, remember, or let me make it clear, is based on a legislative framework. We have an Act of Parliament which tells us how spousal maintenance should be dealt with. And that Act of Parliament is the Divorce Act of 1979. Incidentally, this is liable to change in the foreseeable future, as some of you will know. There is a big drive to start, I think the term that they used is rationalizing, which is a funny term, to bring together one universal marriage and divorce framework in South Africa, which obviously I'm sure most of us can agree is very, very long overdue. Now, Section 7.2 of the Divorce Act, as we have set it out here, is a bit of a mouthful, and I'm going to read through it. And before anyone panics and heads for the border, just bear with me, we are going to unpack it. And it reads as follows, and I will try and speed read without stumbling over my words. In the absence of an order made in terms of subsection 1, which is a settlement agreement, section 7.1 of the Divorce Act, with regard to the payment of maintenance by one party to the other, the court may, having regard to the existing or prospective means of each of the parties, their respective earning capacities, financial needs and obligations, the age of each of the parties, the duration of the marriage, the standard of living of the parties prior to the divorce, their conduct insofar as it may be relevant to the breakdown of the marriage, an order in terms of subsection 3, and any other factor which in the opinion of the court should be taken into account, make an order which the court finds just in respect to the payment of maintenance by the one party to the other for any period until the death or remarriage of the party in whose favor the order is given, whichever amendment may first occur. Sure, I made it very, very well up to the last sentence, and then I nearly fell down over my tongue. Right, this is a mouthful. Now let's unpack it. It's actually very, very simple. This is section 7.2. This and this is the exact same wording. Understand that section 7.2, more than anything else, is a laundry list of considerations. The court may, that's the first word over here, may implies a discretion, not an obligation. Therefore, the first thing that we must know about spousal maintenance, and I know this is one of the questions that came in with the registration form, so I hope this will clarify to the person posing the question. Spousal maintenance is not simply for the asking. The court has a discretion to grant it, and the court must look at a number of factors. Over here we have 1, 2, 3, 4, 5, 6, 7, 8, 9 factors that the court must look at. Ninth factor is in fact a catch-all, and the eighth factor is a very specific one, which we're going to see less and less of as that generation is no longer applicable. And just for clarity's sake, this refers to a redistribution order in terms of marriages registered prior to the Matrimonial Property Act 1988, which was basically where the accrual system was brought in. So there is a mechanism, if you are married prior to the accrual system, that the court could still make an order for some sort of asset redistribution. So this we're not really going to see, and I'm going to actually take it out. So what we've got is we have 7 factors that the court needs to look at, plus a catch-all. Okay. Number 1, existing or prospective means of each of the parties. Now, let's go back to means. Sure, that's a terrible square. Those who can't follow along my pencil drawings are very lucky. What does means refer to? Now, if we look at means, I've got it in here. Means includes the net monthly income from all sources, as well as assets and savings with monthly commitments and liabilities taken into account. So you look at the person's financial position in the broadest sense. Now, means, once again, is divided into 2 things. You have your existing means and your prospective means. Why is that relevant? Let's understand the concept of spousal maintenance. Now, understand the Divorce Act was written in 1979. Times were different back then. If you even look at the case law, for a bleeding heart liberal like myself, it makes one's blood run cold and your hackles raise because of the terminology that is used in these old cases. They always talk about the husband being the breadwinner and the wife being the housewife. That's how these old cases generally used to talk about it. And what they would generally refer to is the rehabilitation of the claimant spouse, generally in those cases, in the old cases, the wife, back into the workforce. So existing means what is my income, my expenses, my assets, my liability right now at this moment in time. Prospective looks at, within a period of 6 months, 1 year, 2 years, 3 years, 5 years, what will my financial position be? I had a divorce case some time back where my client was working. I think he was a doctor. I can't remember 100%, but what I can remember was this. His wife at that stage was in her final year of studies for her LLB, ironically. She had already secured articles, and we were easily able to sit and say, but hold on a second. She's now finishing up her LLB. Let's accept as a given that she's going to article for 2 years and earn peanuts, because attorneys are buggers like that. So let's consider that you will have to maintain her for 2 years to upskill herself to become an attorney, and at that point she would generally be self-supporting. Just an example to show you prospective means. So there we do need to sit with our crystal ball a little bit and look at what they could potentially achieve if they put their mind to it. Then we look at the parties' respective earning capacity. Now, let's just do subdivisions here. Now, for Section 1, we already subdivide into 2, existing and prospective means of each of the parties. So our subdivided into 2 is going to subdivide into another 2. Existing means of husband, existing means of wife in a traditional binary, non-polygamous, heterosexual relationship, right? In terms of prospective, for husband and for wife. Then if we look at their respective earning capacities, once again, we need to look at each. Husband, wife. Earning capacity is simply almost a subdivision of means. And the earning capacity, I think, is very, very broad. I had a discussion with a client yesterday who said, but I want to claim this from this person because this is what I could have earned as a project manager at that stage, but I was actually doing rentals management. And I said, well, this is what I work as an attorney. If I go and do a head gasket on someone's car, because I'm an old West Rand boy, and I know how to do head gaskets, are they going to be paying me the same rate? Well, not necessarily. If the husband is a medical doctor, a neurosurgeon, and elects to go and work as a bartender, is that his earning capacity? Is he really earning in terms of his capacity? Very broad, once again. Very, very case specific, once again. Then we look at their financial needs and obligations. Once again, subdivision on a subdivision. What are your financial needs of husband and wife? What are your financial obligations of husband and wife? Then we sit with the age of each parties. Age of husband, age of wife. Then we look at the duration of the marriage. Simple. Then we look at the standard of living of the parties, and don't forget, guys, prior to the divorce. I had an opponent pleaded in a particulars of claim just the standard of living of the parties. You have to plead the standard of the living of the parties, standard of living of the parties prior to the divorce. The underlying question here is, when it was going well in the relationship, how was the standard of living? Just because it's going bad now doesn't mean that either party needs to suffer. And then this is a very contentious one. Their conduct insofar as it may be relevant to the breakdown of the marriage. Let's talk about fault principle. The attorneys among us will know exactly what the fault principle is. And ironically enough, the Divorce Act 1979 did away with the fault principle. Now, what that means is before 1979, when the Divorce Act came in, the zeitgeist and the legal understanding was that someone is at fault for the divorce. Blame must be assigned. 1979, the Divorce Act came along and said, listen, all I'm interested in is there an irretrievable breakdown of the marriage? If there is an irretrievable breakdown, you will get your divorce. In other words, the fault principle has fallen away insofar as getting your decree of divorce is concerned. However, the Divorce Act contains two sections where conduct and potential fault principle still find application. One is Section 9(1) of the Divorce Act, forfeiture. It looks at misconduct of the parties. And the second one is Section 7(2) of the Divorce Act 1979. To the attorneys, as something free, gratis and verniet, if you are ever involved in a divorce where spousal maintenance is in question and your opponent says, do we agree that in a pretrial that a divorce must be granted? You can say yes. However, the divorce must be granted for my reasons, not for your reasons. Why? Because if you don't, you get the wrong judge, wrong magistrate. They say, but you've agreed there must be a divorce. I'm not going to hear the reasons of the breakdown of the marriage. This is common cause. And you have disqualified yourself of a whole section of your Section 7(2) issues, right? And then any other factor which in the opinion of the court should be taken into account. I'm busy with a divorce now where my client made a donation to his wife of just under 12 million rand. Here's a gift. Nice to be in that marriage. Is that something that needs to be taken into account in terms of spousal maintenance? I would say absolutely. He wouldn't divorce him. No, you know what? I don't think I would either, and I don't think my wife would be too cross with me if I didn't divorce him either. So those are our factors which the court will look at. And how the court looks at these factors really comes down to case law. I'm not going to go into too much depth with this, but to go on to say the court may then make an order that it finds just. That is ridiculously broad. Look at the discretionary elements. The court may, having regard to all of these things, plus any other factor, make an order which the court finds just in respect to the payment of maintenance by one party to the other for any period until the death or remarriage of the party in whose favor the order is given, whichever event may first occur. Now, ladies and gentlemen, I want to pose this question to you. If we talk about rules of thumb in maintenance, if we look at the legislative framework in terms of minor children, section 15.3, any such amount as the maintenance court may consider fair. If we look at Bersey versus Bersey, which says relative means and circumstances and needs of the child, the incidence and the duty depends. And we look at section 7.2 and we say we have all of these discretionary words, may, having regard to things like any other factor, what the court finds just for any period. My question is simply this: are rules of thumb a good idea, or are we doing an injustice to our clients by saying this is a parent share, this is a child share? This is what is reasonable for a child. Absolute amount. You must pay 3,000 Rand, regardless of whether you earn 100,000 a month or 5,000 a month. It's food for thought. Those guys who mediate maintenance matters, and I can see there are a hell of a lot of you in here, I want to appeal to you and emphasize to you the immense good that you can do in helping parties to reach practical solutions when it comes to maintenance issues. Right, klaar gepreek, as we say. Let's go into the basic principles. Now, what we're going to do here is we're going to take section 7.2 and we are going to distill it down. Is the distillation perfect? No, not at all. Are we losing some things in translation by distilling it down? Yes, potentially. However, it is very, very worthwhile just for illustrative purposes. The main consideration when it comes to spousal maintenance is a bona fide need. I am in need of spousal maintenance, right? The second consideration, folks, and please don't ever lose sight of this. I've seen so many people have so much heartache with this. Spousal maintenance must be claimed and ordered at date of decree of divorce. If you get divorced and there is no order, good luck getting spousal maintenance. Why? Section 7.2 says that a court may make a spousal maintenance claim at date of decree of divorce simultaneously with the divorce being granted. Don't ever settle matters by saying neither party will pay maintenance to the other and either party can run to maintenance court. Absolutely, Emma, you hit the nail on the head. We're going to look at token maintenance shortly. That's exactly where it came in. Right. Case law suggests, and the first, or one of the prominent cases, I wouldn't say it's the first, where this was taken apart was a I think it was a Durban and Coastal Division, Pillay versus Pillay. It's not a reportable case, but it has been referred to by reportable cases. And it suggests that, and the case actually uses the word little or no maintenance, will be ordered if the spouse is young or relatively young, they're well qualified, they have no children or no young children they need to look after, they have worked throughout the marriage or are working at the time of the divorce, if they are in good health or the marriage was of short duration. Now, once again, there is no guideline as to 10% of the consideration must be on duration, 20% must be on qualification, etc., etc. They must be considered holistically. You have to look at them as a complete picture. Now, I want to ask this question, and guys, please feel free to use the comment box and tell me what your thoughts are. This maintenance framework is incredibly broad, and it can be problematic. Is there an alternative? Is there any other way to look at maintenance other than considering each matter on its own merits, as broad and as fluffy and as difficult as that may be? Now, let's go into the types of spousal maintenance. Spousal maintenance can be one of four things: rehabilitative, can be lifelong, can be lump sum, or it can be token maintenance. And what that comes down to is the following. Rehabilitative maintenance is temporary maintenance to help the claimant's spouse back on their feet. Let's take rehabilitative back and let's look at its legislative framework and foundation. The court may make an order which it finds just in respect of the payment for any period. Any period. So the court can say your ex-spouse needs 6 months to get back on their feet. For rehabilitative, we look at things like cash maintenance, resettlement allowances, rental payments, medical aid payments, those sorts of things for a specified period of time. Lifelong maintenance, Lee had a beautiful case, and I'm going to pick on you a bit, Lee, to share that with us, obviously not disclosing the parties. Our client was, I think, 55 years old, plus minus, married to an incredibly wealthy man, a long marriage of about 25 years, got divorced. At 55, she'd been out of the workforce for 19 years. What are the prospects of that client finding work again? Very slim. Very, very, very slim. And at the end of the day, we got lifelong maintenance. I think it was 55,000 a month. Hey, Lee? Okay. And that is lifelong maintenance. And really where that comes down to is where there is no prospect of the claimant's spouse being gainfully employed again. It is not rehabilitative. Die koel is deur die kerk. The ship has sailed. This person simply cannot find work. Where I have seen a lot of fights on lifelong maintenance, it's based on age, it's based on health, and also mental health. I've seen a lot of matters where there's huge fights because the claimant spouse says, I have a mental health problem, unipolar depression, or an MPD or BPD or whatever the case may be, and I simply cannot work. It's debilitating. Then one can get a lump sum maintenance, which is simply a once-off large capital settlement in consideration of any future maintenance obligations. This very often happens in settlement agreements. I'll give you 2 million rand, but I'm not paying you a cent more ever in my life. This is go away tax, in other words. And then we have token maintenance, which is what Emma was referring to earlier, which is a placeholder order, which is made at date of divorce, which enables the claimant's spouse to then approach the maintenance court at a later stage, just leaving the door open. here is a nice wording, and I'd like to share it with you. It's not my wording. It was the wording that we got in a matter that we inherited that Lee dealt with at one stage. And I think it's a very interesting wording for settlements. Please don't construe this as me saying, put this wording into your settlement agreements. That's not what I'm saying at all. What I'm saying is this is a very interesting example wording, and it's food for thought. Make your own mind up about it. And it's as follows. Plaintiff shall approach the maintenance court for adjudication of the quantum of her claim for spousal maintenance within 30 days of date of decree of divorce being granted. 2, until ordered otherwise by the maintenance court, defendant shall pay maintenance to the plaintiff in an amount of R whatever, shoot for the moon, per month payable to plaintiff's nominated bank account no later than the first day of every month. In the event that plaintiff does not refer the matter to maintenance court within 30 days, defendant's liability to pay maintenance to plaintiff shall cease. I'm not saying it's good. I'm not saying it's bad. I'm saying this is what I saw in a matter that we got. And we inherited it after this divorce was finalized, and the client then came to us to say, listen, as maintenance specialists, please take it to maintenance court for me after the divorce, which we then duly did. Maintenance court entertained it. Once again, I'm not advising you to use this wording. It's just an interesting way to consider it and to look at it. So let's look at the steps for spousal maintenance. What are the reasonable needs of the spouse claiming maintenance? Number one, step one, we are once again going to look at the need. Need is critical. As I mentioned to you previously, let's go back to the legislation, our section 7.2. Spousal maintenance ain't just for the asking. It is something which is given by the court if it feels that it would be just, or if it concludes that it would be just, having consideration to the section 7.2 factors, which all boils down, as I've said to you earlier, a bona fide need. So number one, the claimant spouse must establish a need. Now, what do we consider in establishing that need? Section 7.2 tells us existing or prospective means, earning capacity, financial needs of that spouse, age of the spouse, standard of living prior to the divorce, etc. Refer back to the Act. Number two, one would look at the means. Once again, means. Everything is means. Net monthly income from all sources, assets and savings, monthly commitments and liabilities, etc. So to establish the means, one would look at the means of the supporting spouse. I need 500,000 Rand a month to survive. Sure, shooting for the moon. But my ex-spouse can only give me 100,000. Where do you draw the line? What is reasonable? Lee, obviously, you're going to share with us a little bit of how the court did that. I'm throwing you in the deep end. I wish I'd warned you beforehand. No, I'm actually glad I didn't, you bugger. Anyway, what does the court consider fair? Consider the duration of the marriage, the standard of living of the parties prior to the divorce, conduct of the parties, an order in terms of section 7.3 and any other relevant factors. Then the court may make an order it considers fair. How does that order look? Rehabilitative, lifelong, lump sum, token. Token, generally, it's something which is more done these days by means of settlement, but that's what it comes down to. All right. Okay, I have one more slide. Then we're going to go over to the practical side of things with Lee, how maintenance court functions. Do we have any Q&A on just the basic overview of the maintenance framework, at least for minor children, major dependent children, and spousal maintenance? Please speak now, forever hold your peace. After this Q&A session, I'm going to go through one more slide, and then we're going to hand over to Lee. We've got 15 minutes for this section. JP, always lucky to see you. How are you doing?
Mervyn, English. Again, an excellent course, excellent webinar. I have a question with regards to token maintenance.
Okay.
I was in a mediation session with a co-mediator, and while we were discussing the options for spousal maintenance, the comment was made that token maintenance is not on the table anymore.
Well, it depends on a number of things. You know, in the olden days, you would see a lot of these orders of R1, for example. What I think is happening more is where we are going now in terms of this example wording that I gave you guys a little bit earlier. Let me just erase that line over there. It is dangerous to concede to token maintenance, and the reason being, to an extent, you concede liability. Remember, spousal maintenance is really a two-pronged approach. Number one, you establish the maintenance obligation. Number two, you look at the quantum. So if you are for a defendant, you generally say, you are not entitled to maintenance, so we don't even have to look at the quantum. You should not get it, full stop. But if you do get it, the quantum must be lower than you say it must. So it's always a two-pronged approach. Think of your motor vehicle accidents, merits and quantum. It's always those two aspects. So this is something which I think we're going to rather see in place of token maintenance. So here is an interim order. Take it to maintenance court at a later stage, but do it within such period of time, or you would have missed the bus. If you do have the opportunity, JP, please do speak to the person who was in the mediation with you, and ask them if they can furnish you with the authority to support that proposition that token maintenance is completely off the table. And please distribute to me. I will then distribute it to everyone else present. Rikma, how's it going in the Fair Cape? Have you got something to share with us on this issue of token maintenance?
Good morning, everybody. Yes, thank you so much for hosting, Mervyn. So I'm just a bit confused about token maintenance because I've never understood it, so I've never really used it. So excuse my ignorance.
No problem. Look, yes, go for it.
I just want to quickly ask my question, and then you can elaborate. So with regards to point 2 of your concept wording that you caution to use or not use,
yeah,
would that not, if the party approaches the maintenance court, would that not amount to a variation of which the requirements would then be different? And you know, because if I would settle for like R1,000 a month as a placeholder, right?
Yeah.
I would not be able to approach the maintenance court and say, I want to open a maintenance, inquiry. They would ask, is there an existing maintenance order? Yes, there is. So then the maintenance investigator would say, well, actually, you need to ask for a variation.
Yeah, well, that's a very interesting one. We had this very same thing in a matter that Lee did. Lee, if I can just ask you to unmute yourself. In that case, did you refer it as a variation, or was it a new from scratch kind of Form 2 maintenance application?
So Merv, it can be referred as a variation. Obviously, if you do that, you need to provide the previous order that was granted. If you do submit it as a new order that you're seeking, then the court is going to ask the history of the matter. Was a previous order granted? And in that case, then you'll obviously be using the wrong form to refer the matter to maintenance court, because it's not considered a new application.
Yeah. Also, Rigma, just bear in mind your Havenga clause, hey? The Havenga clause obviously being a clause that says any party can approach the maintenance court and they won't be required to show a change in circumstances. So I think it also falls in line with that to a large extent, hey?
Noted. Thank you.
Cool. No problem at all. Any other questions, folks? All right, everybody, welcome back. I hope everyone's had a good break and that we're all ready to roll for the second part of the session. Lee has alerted me in the break that there were a few questions which were raised in the chat bar in the first portion of this webinar, which I didn't get to, which I would like to quickly just clarify, if that's okay with everyone, before we go into Lee's section. I think these are very, very good questions which bear discussion. The first question, and I'm going to actually just circle back to this issue of token maintenance. Alfred asked, can we just have a look at token maintenance or placeholder maintenance? And I've quickly in the break just had a look at my reference material as well as the reported cases on JUTA. So JP, in terms of what you raised before the break, I just want to clarify that, okay? So I'm going to read out and share with you all just an extract from the fantastic reference work, The Law of Divorce and Dissolution of Life Partnerships in South Africa. It is a JUTA publication. The author is Jacqueline Heaton. I'm sure most of you will know Jackie Heaton. She does quite a lot of great reference work. She's the UNISA lecturer, and it deals with obviously divorce, but it also looks at dissolution of life partnerships. It looks at Islamic marriages and customary marriages, etc., etc. It is a very, very useful work. If anyone is interested in the book, I'll quickly just paste the details of the book there if anyone is keen on it. So now that I know I'm not going to get sued for plagiarism, let me cite Prof. Heaton and what she says on token maintenance. She says the following: even if a maintenance order in terms of section 7.2 is not warranted at the time of a divorce, either because the person who's claiming maintenance has no immediate need, or because the maintenance debtor lacks the ability to pay maintenance, a token or a nominal maintenance award, such as for R1 or R10 per month, may nevertheless be granted. This might be done where it is probable that a maintenance need may arise on the part of the defendant, or on the part of the claimant, my apologies, or that the maintenance debtor will be able to meet the claimant's existing maintenance needs at some stage in the future. So it is a nominal amount, a R1, a R10, a R100, just to keep the door open. Prof. Heaton then goes on to say that there is criticism to it in terms of the fact that you would have to approach the court on a variation. So Rikma, you are 110% correct in the statement that you made earlier. It is a variation application. Then JP, to answer your question, I've had a look at my JUTA law reports. The most recent case that I can find in the law reports is MG versus RG. It's a 2012 case, and it was KwaZulu-Natal, Pietermaritzburg. I've pasted the citation for you. And basically what it was, I went through it very, very briefly. It criticizes token maintenance, but it doesn't say that it is unconstitutional or that it doesn't exist in our law anymore. So there are criticisms towards spousal token maintenance. There does not seem to be any indication that it's not a part of our law anymore. If anyone is aware of newer case law in that regard, whether it's reported or unreported, please do share it with me. But I really hope that that clarifies the position. For those who need more clarity on the issue of token maintenance, there's a beautiful 3 pages in Heaton where she sets it out. Yes, JP. JP, you're still muted. There we go.
Mervyn, I think the challenge is the fact that if the legislation changes to allow for a maintenance claim to be made by an ex 2 years, 3 years, 5 years down the line, we would not need this. But a divorce that's granted without spousal maintenance and that person's circumstances changes without the nominal or the token maintenance, the door is shut.
Yes,
and that's the issue. And
I agree with you. Yeah.
And given just if we consider the impact of COVID, the financial impact on families only in South Africa, circumstances change, and because we cannot foresee the future, and taking into consideration age and even gender, don't want to open a can of worms there.
Interesting point you make.
Because what we see today is not necessarily the husband being the breadwinner anymore, but we see more and more women earning more than men. So there's so many factors that you need to take into consideration. And you know, you said something profound. You said,
oh, I'm glad to hear that.
You were addressing the mediators, and I get goosebumps now. You said that we can help our clients reach practical solutions. We are in a position to say, guys, let's not only consider today, let's consider the future and really draft things that would enable people down the line to still be able to open the door at maintenance court. Whereas if we don't address it, and a problem arises 6 months, 10 months, 12 months, 18, 2 years down the line, what then?
Yeah, look, so it's a very interesting point that you make, JP, and let me tell you what my opinion on it is. So obviously understand that the idea of spousal maintenance, and I don't want to take too much of Lee's time, I know we've got limited time, but this is incredibly important. The idea of spousal maintenance is rooted in the common law principle that stante matrimonio, i.e. during the subsistence of the marriage, spouses have a reciprocal duty of support towards one another. Jake, I'm just going to mute you. There's a little bit of background noise. Please unmute if you want to comment. They have this duty of support stante matrimonio. The minute the marriage comes to an end, the minute, in other words, the parties say, I used to, but I don't anymore, in other words, take backsies, let's have a mulligan, i.e. let's get a decree of divorce. That moment that the decree of divorce is granted, that obligation of reciprocal support between the ex-spouses comes to an end. And I would be very surprised if our legislature actually changes that position. It's not within the zeitgeist of where we have been going. Look at the once and for all principle. Can you imagine the can of worms that you open up? That parties go to court and they say, right, we are now divorced. And 3 years down the line, you get a maintenance application against you by your ex-spouse. So I don't foresee that the legal position is going to change. And that's where token maintenance comes in, to say, let's keep the door open. Exactly as Heaton says. Heaton says it's for a situation where there is the foreseeability of a maintenance claim arising in future, and you want to keep the door open, or there is a maintenance claim now, but the debtor, let's say the dominant spouse, does not have the means now to pay, but they might have in a year's time, then that door is open. And I don't foresee that the legislature is going to change that anytime soon. And that's why mediation becomes such an important part of trying to troubleshoot these things. Teresa, Always good to hear from you. What's your view?
I tend to agree with you, Mervyn, in the sense that even in mediation, you do mention the fact that any form of maintenance can actually be looked at by the maintenance court, okay, in terms of legislation. But it's also an interesting query because let's say, for instance, you have someone that has a rehabilitation maintenance agreed to, and the parties in mediation agreed to this rehabilitation maintenance, let's say for a period of, say, 4 or 5 years, because let's say one of the parties, the recipient of the mediation, is going to enroll in some course, or they are going to, re-educate themselves, or they're going to re-establish themselves in a workforce or whatever. And in that period of maintenance that's already agreed upon, it should happen that something unforeseen happens. In my brain, that would warrant going to the maintenance court and saying the rehabilitation maintenance, for instance, needs to be extended for 2 years or 3 years or anything of the sort. But I am still very much against the whole open-ended R1 maintenance, because in 10 years from now, something is going to happen, and then she's going to run back to her ex-wife, as you say, and then try and claim maintenance on that basis. I don't think the courts would look kindly on that, even though it is possible.
Yeah, I must be honest, token maintenance is not something you see incredibly often. And I mentioned that placeholder. For example, if I can go to that wording that I showed you earlier on the matter that Lee inherited. I also don't know if this really is token maintenance. It just says, the trial court's not going to adjudicate it. Here's a holding pattern, almost like a Rule 43 kind of vibe. Go to maintenance court. I have never seen a settlement where there was a token maintenance, a R1 or a R10. What I have seen is we're going to agree on maintenance now, and we put in a Havenga clause that either party can approach the maintenance court. JP, yes. And then Rikma, I see your hand is also up after JP.
No, Mervyn, I'm happy. Thanks.
Happy, as long as you're happy, JP, I'm always happy. Right. Rikma.
Mervyn, sorry,
Yes.
can I back in? I can't seem to put my hand up. I have a technical problem somewhere. Can I back in? Do you mind?
Yeah, no problem. You can briefly butt in. No props.
Thank you. Just something that occurred to me while you're talking, and I'm just wondering if there's any value in this. If you're doing a mediation with and you're having problems with the maintenance discussions, and the parties are desperate to get divorced, I'm wondering if you can do a placeholder or a token maintenance payment for the children as well, and come back to that at a later stage, or let the party settle it in another manner. I'm just trying to think if creatively that would work.
I have done it previously. It's in fact easier to do with children than it is to do with spousal maintenance, for the simple reason that ex lege, in terms of the Children's Act, you have a duty, and in terms of major dependent children, obviously in terms of the common law, you don't have to establish it at date of decree of divorce. So I have had wordings where the parties have said, the parties will, subsequent to date of decree of divorce, negotiate with one another, or if they can't reach agreement, then they'll go to maintenance court. The only upshot of that is I've had, and usually I've been in court with a plaintiff who's then the primary resident parent, is I would just lead testimony in front of the judge to say, look, madam or sir, what are your means funds to maintain the children without any intervention by your spouse. If they do have sufficient, then the court is generally quite happy with it. But it is definitely something you can do if the parties are desperate to get divorced. Yeah.
Just creative way of doing things. Thank you, Mervyn.
Absolutely. Anytime. Thanks, Alfred. Rikma, over to you.
I don't know. It says unmuting on my screen. Can everybody hear me?
Yebo.
Right. So, I mean, I've got a controversial view on this. I don't know if I'm opening a can of worms, but
Jeez, I love it, love it, love it. Bring it.
look, I'm going to qualify this by saying I'm not a mediator at all. I'm a litigant at heart. So my sort of back gets up when I hear, you know, the token maintenance being sort of a placeholder to assist the mediators in reaching, fast tracking an agreement between the parties. But essentially, is that not just kicking the can further down the road and just passing the buck to someone else to go and sort out? Because those spouses must then go and approach an attorney. Sure, you can go and approach the maintenance court yourself, but in reality, you don't get anywhere unless you get an attorney. And then they have to go and incur all those fees, whereas whilst you had the teeth of a Rule 43, whilst you had the, potential consequences of the patrimonial consequences to sort of use as leverage, why on earth would you, sort of finalize a divorce or fast track a divorce to the disadvantage of someone, in terms of Jackie Heaton's, book, saying, if there is a situation where there's a possibility that one party might be dependent or need spousal maintenance, why kick that to the maintenance court?
Okay, so I think there are a couple of you've actually opened a very lacquer can of worms, and I wish we had more time to actually properly digest and chew on all the worms. But I think let's just draw a distinction now. First off, in terms of token maintenance, under Jackie Heaton's description, and what the case law really bears out also, is that either you give it because the person who is claiming maintenance has no immediate need for maintenance. So they have a potential need at a later stage, but they don't need it right now, but they foresee that they might need it at a later stage. I don't think token maintenance is designed to be in a case where you have a spouse who desperately needs maintenance now and say, look, you can have R1 and then go to maintenance court. For that, I think this holding pattern kind of wording that Lee had in her case, the slide that I'm on now, is more appropriate to say, look, here's a holding pattern maintenance, and then go on at a later stage. But I take the point, there is a benefit and drawbacks to this, and obviously when it comes to litigation and law and family law more than anything, we know that nothing is absolute. So there are cases potentially where it might be in both spouses' interest to say, let's kick the can down the road. Let's talk about, for example, a case where parties are married in community of property. Breadwinner spouse is the 100% shareholder in a PTY Limited, for example, has potentially signed a surety. There's maybe big litigation against the PTY Limited, which could affect the joint estate. And then the claimant spouse might also be in a position where let's say summons has, for example, not yet been issued. They say, well, I want to get out of this joint estate as soon as possible before this summons lands. So there are various ways and means, but I haven't seen it a lot in practice. But a very, very good contrary view, and I appreciate it, Rickma. I think the bottom line is one must, when dealing with any sort of settlement, you must find something that works, and I think most of you will know that this is a theme during the first half of this presentation, is there are no absolutes. It is not a case of this is what you have to do in every case. A strategy might work for one case and it might not work for another case. All right, then, MI, just your two questions, and then, guys, we do have to go on, otherwise we're going to run out of time quite severely. Refer to existing circumstances and prospective circumstances which cover token maintenance. Okay, and then does the Havenga clause not cover this? Just to clarify, MI, the Havenga clause deals with a variation. It's not a placeholder, so there's an actual order for maintenance made. Now, the requirement generally to get a variation in maintenance court, which Lee will touch on shortly, is good cause shown, which is usually a change in circumstances. Havenga clause says that either party can go without a change of circumstances and approach the maintenance court. So it is something that parties sometimes use to fast track to say, you know, just agree to the bad maintenance and you can in any event run to the maintenance court. And then in terms of the book details, I have pasted them above. If you go and look in the chat, I've put it in there together with the ISBN if you'd like to order it. And absolutely, Teresa, thanks for your comment also in the comment box. I love it. It's so valuable to share different opinions on these things. Lee, you seem to have disappeared. Are you there?
I'm back, Merv. Sorry.
Are you okay? Excellent.
Yes.
Right. I'm going to highlight Lee. I'd like to introduce Lee to you guys. This is her first time presenting fully, so she is nervous as hell. So please ask her all the difficult questions and make her even more nervous. Put her on the spot. She's one of the attorneys at my firm. She's going to be talking to us about her experiences in maintenance court. And yeah, take it away, Lee. Very warm welcome and thank you.
Thank you so much for the opportunity, Merv. I really do appreciate it. So today we obviously just want to canvass with you guys the concept or the practical elements of what happens in maintenance court. We know the Maintenance Act would say what should happen in maintenance court, but I think most of us are aware that once you get to maintenance court, completely different story. The clerk has their version, magistrate has their version, client has their own version. So unless you find yourself physically appearing in maintenance court on a daily basis, it is difficult to establish and explain to your clients why the processes are constantly changing. Every maintenance court I've ever been to, they each have their own processes. Every clerk is of a different opinion, so it's very complex to explain to a client, this is what is supposed to happen. However, if we get to maintenance court, this is possibly how it could change. Now, the first thing that I'm going to look at is Section 6.1 of the Maintenance Act. Section 6.1 deals with whenever a complainant to the effect, so any person who's legally liable to maintain another person fails to maintain such a person, that good cause exists for the substitution or discharge of a maintenance order, or that good cause exists for the substitution or discharge of a verbal or written agreement in respect of maintenance obligation, in respect of which there is no existing maintenance order, you can apply to maintenance court. So essentially, in layman terms, what is this section telling us? This section is saying, when can we go to maintenance court? When do we approach maintenance courts? In which scenarios? So you'll see on the slides here, the first scenario is where someone is legally liable to maintain you and has failed to do so. So this could be in terms of a court order. We do have instances where there's no court order at all, but we know that there's a duty to maintain the children, or there's a duty to maintain the wife, duty to even maintain the parents. Earlier, we were discussing the idea of maintaining your parents and how that works. The second scenario we have is where there is a maintenance order in place. So perhaps you guys have been to maintenance court before, all the parties have got divorced and there's now a divorce order. So substitution or discharge would either be, hey, we want to change the agreement that we currently have, so circumstances have changed. I want to lessen the maintenance that I'm currently paying. Perhaps I've lost my job. We saw a lot of those applications during COVID. We were inundated with applications of those nature. Then there's also, I need an increase for the children for maintenance because what perhaps the court ordered 7 years ago is no longer enough and it's no longer applicable. Even though we get scenarios where we add in a clause to deal with the increase and how that's going to work over the years, many times people don't actually stick to the increases. Essentially what they just do is they pay the maintenance. So if the settlement agreement says you pay 7,000 Rand, they'll pay 7,000 Rand regardless of the increase that's supposed to happen. So there are various instances where we can approach maintenance courts. And the last instance, there is substitution or discharge of a verbal or written agreement in which there's no existing maintenance order. So perhaps mom and dad were co-parenting and they had agreed that dad would pay 2,000 Rand maintenance per month for the child. This was not placed in writing. They then obviously can approach maintenance court to say, hey guys, there's this verbal agreement we had. Dad's currently not paying. He paid this for about 4 years. So essentially we can say that this was the agreement. Both parties were in agreement with and consented to such a verbal written agreement. But there was no order made. Can you please assist us? Next slide, please, Merv. Thanks. So now we're going to look at...
I'm going to go a bit slower just so you have a chance to breathe a bit.
No problem at all. Sorry, if I'm going too quick, I do apologize.
My
brain is like working very quick at the moment. So
that's good.
My apologies. Alrighty, so the next thing that I want to look at, obviously, is when you get to maintenance court, right? As I've explained, you get various applications that can be launched in maintenance court. But as I explained earlier, when you get to maintenance courts, it's a very different story. And again, this is based on every maintenance court. Randburg has its own version. Roodepoort has its own process. The clerks are different. The clerks say different things. There's honestly no structure and order when it comes to how the courts function. So if we look at Section 6, now what happens when you apply for maintenance, no matter what the application looks like, you will get a date which you need to appear at maintenance court. Obviously, such a date, you need to make the respondent aware of the court date so that he or she actually does appear at court on the day. Now, the first appearance is what we call the Section 6 appearance. It's not before a magistrate. Here, essentially, you sit down with a maintenance officer in their office. Some maintenance officers are very nice where they explain to you what is the application that the applicant has brought to this court, what is the nature of it, what are they seeking. Then the maintenance officer will then explain to both the parties at the Section 6 inquiry that documents need to be exchanged. Now, this is usually 6 months, depending on whatever the application is before the courts. It might be bank statements, pay slips. It might be bank statements dating back to when the maintenance wasn't paid, if it's an arrears maintenance application. It could be documents stating that you're still actively seeking employment. It could be invoices and statements in support of your income and expenses. So the maintenance officer has the duty to sit with the parties and say, guys, this is the application that's before the court. This is what the applicant is applying for. Try and maybe find out also the history of the matter. Was there a previous order made? What did you guys previously agree on? Have you, in fact, ever discussed maintenance? And if not, now's a good time to start the discussion. So the maintenance officer will start with that. They'll then obviously explain that documents need to be exchanged between the parties. I have had an instance with our spousal maintenance claim in Randburg where the respondent just basically said, I'm not giving any documents. Affordability is not an issue. I'm not giving any documents. The applicant must come and tell me what money she needs, what maintenance she requires. And we still said, well, this is bizarre, because if the respondent turns out at a later stage and says, I can't afford the maintenance anymore, we have zero documentation before this court. And the maintenance officer turned around and said, well, I'm not going to order him to provide any documentation. He says affordability is not an issue. We'll take his word for it. In the beginning, I was just like, this is insane. This isn't going to work out for my clients. But at the end, we did get a good order. And obviously, it's to his own detriment that he didn't provide documents, because the magistrate literally had the power to order whatever maintenance she thought fit. It could have been 100K, it could have been 200K. She literally could order anything that she wanted to, because there were no documents before the court on the part of the respondent. So going back to the Section 6, as I said, the maintenance officer will explain to you what is the application before the court. Guys, we need to exchange documents. It's very important that there be a documents exchange in the Section 6 inquiry. Your matter will not proceed to a Section 10, which I'll get to just now, if no documents and updated documents to the last date have been exchanged. Then what also happens at the Section 6 inquiry, and bear in mind the maintenance officers are not obliged to deal with this, but some of them do. I've had a very nice maintenance officer in Ridderput that tried to actually settle the matter in Section 6. He sat with the parties and he said, I'm going to be a very independent third-party officer of the courts. I want to help you guys to settle this matter. I'm telling you that if the matter goes to trial, your attorney is going to be very expensive. Let's discuss settlement. Now, they aren't obliged to do that. Some of them just are really passionate about the job that they do, so they will sit with the parties and try and assist. They can discuss settlement. They can ask the parties to step outside and try and mediate, but this is not a requirement. It's really up to the parties in this sense to say, let's actually discuss settlement before we go to trial. So that's what happens at a Section 6 inquiry at maintenance court. As I've explained to you, this is different in every court that I've ever been to. No court functions the same, but there generally should be, how can I say it, a fixed process involved, but don't take my word for it if it doesn't happen this way at your Section 6 inquiry. Now, Section 7, this is obviously the investigation by the maintenance officer that takes place. Now, again, here, there probably would have been an exchange of documents already. The maintenance officer will have the opportunity to really go through the file and say what is being claimed for, have all the documents been exchanged for trial, have the parties try to reach settlement. If there are any people that need to testify at the trial, the maintenance officer, as you'll see from the slides, will need to ensure that the subpoenas are served. If someone hasn't showed up for the Section 6 inquiry, the maintenance officer has a duty to ensure that the subpoena is served. I've got a matter now where the gentleman hasn't showed up for the Section 6 inquiry. We were informed to collect a subpoena from the courts and have it served. But when we went to court the other day to inquire on it, they said, no, they're arranging everything. We must just come and show up on the day. So I was very grateful for that because it's very rare that they actually do their job. They normally just hand it to the attorney and be like, please sort it out. So that's really awesome when they actually do their job. And yeah, as it says there, the maintenance officer investigates everything. Is everything trial ready? Have I attended to, being the maintenance officer, have I attended to everything that I've needed to? Have the parties complied with the rules of court? Are we ready to trial if the matter needs to be before a magistrate? The next section that we deal with is the Section 10 inquiry. This is obviously a trial, a formal trial before a magistrate in a courtroom, okay? I never advise parties to go this far. It's very expensive if you need to prepare. The matter that Mervyn spoke about that I had, the spousal maintenance matter, I mean, I think we ran for something like 10 days on trial. We had counsel briefed. My client really paid a lot of money to get a maintenance order, but it sometimes does need to go that far if the parties genuinely can't settle and reach agreement by consent. So Section 10 is really a trial in court before a magistrate. It's a very formal hearing. The maintenance prosecutor will be present. The magistrate will be present. The clerk of the court will be present. The stenographer will be present. The parties themselves. If they have any legal representation, the legal reps will also be present in such a hearing. Now, it's very important that before you reach a Section 10 trial and before you're given a date for a Section 10 trial, that all documents are exchanged. I promise you now, you will frustrate a magistrate if you get there and say, I want a trial, but documents are outstanding. The magistrate's literally going to say, please take your file, get your house in order, get out of my courts and come back when you're ready, okay? So it's important. All docs need to be exchanged. And more importantly, guys, you need to ensure that your bundles are indexed and paginated. You can't be throwing documents into the court file and be like, magistrate, please figure it out. The magistrate's going to be very mad with you. They're going to ask you to please paginate, number your bundle, make it very neat so they can actually make sense of everything that's in front of them. Now, when we say trial, what does this mean? So it's like any trial that takes place in a court. There's evidence in chief that gets led from the applicant and the respondent. There's cross-examination and there's re-examination. So some matters can run for a day, some matters 2 days, other matters 10 days. It's really dependent on how complex the matter is and how much evidence we need to work through. Now, the magistrate obviously will, after having heard the evidence before the court, will make an order. So that is where we say order has been granted. And the next step, most important step, is that we enforce the order. This is generally where parties come to us because it's great the order's been granted, but he's still not paying. How do I enforce it? Please, can you assist me? Next slide, please, Merv. Alrighty. Now, when we look at enforcement mechanisms that are dealt with in the Maintenance Act, we get three main sections here, which is Section 27, Section 28, and Section 30. This is obviously the ways in which we can enforce a maintenance order. Now, I will elaborate on each one of them. And if you guys have any questions, please pop it in the message box. And as soon as we have time for Q&A, I'll go through those questions with you. Now, firstly, before I get to Section 27, I want to deal with Section 26 of the Maintenance Act, okay? Now, Section 26 deals with the enforcement of maintenance or other orders. So this basically will set the basis for what I'm going to explain to you in terms of Section 27, 28, and Section 30. Now, Section 26 of the Maintenance Act tells us that when someone fails to pay maintenance in terms of a maintenance order, okay, such order can be enforced in three ways. As set out on the slides there, Section 27, we can have an execution against property. In terms of Section 28, we can deal with an attachment of emoluments, and Section 30 deals with the attachments of any debt. As I said to you, I'll explain all these in detail so that you guys can understand what this actually means. Now, Section 26 goes a step further to say that if an order remains unsatisfied, okay, for 10 days from the day on which it became payable, you can enforce the order in terms of Section 27, subsection 1, 28, subsection 1, or Section 30, subsection 1. All right, so obviously such an application, if you have a maintenance order, the person is defaulted, it's an application that you need to bring to maintenance court, right? Now, the Maintenance Act will always say to you in the prescribed manner, and I'm like, what does that mean? You go to the court, you ask them, this is my story, can you give me the form I need to fill out? Okay, so it's that by application, we mean an actual form you're going to fill out. The clerk will explain to you what documents need to be attached to that application in order for you to lodge it. Okay, so the application, if you're dealing particularly with an order which someone hasn't adhered to, you will need to attach, most importantly, a copy of the maintenance order that was made. You can't go to court and say, oh, they're not paying, they were supposed to pay 10,000 Rand. The clerk's going to be like, okay, where's this order? Where does it say that they were supposed to pay this amount of money to you? So you need to have that order attached to your application. Secondly, you'll have what we call like an affidavit or a statement under oath, basically explaining what is the amount that the person is owing to you. So you'll explain to them there was this order for 10,000 Rand. They were supposed to pay it for 3 months. They've paid it only for 2 months. Therefore, they're owing me 10,000 Rand. Okay, so you'll have to set out in an affidavit what is the amount that's owing to you. The reason that we do that is just so that if the matter goes to trial, people's versions are under oath. They cannot lie. If there's any discrepancies in the case, we can obviously hold them to what they've set out in the affidavit. Now, if we look at Section 27, Murphy, if we can just go back to the slides.
No problem.
Okay.
Please bear with me. My PC is not as fast as you are.
No problem. I think it's my Red Bull. It's really helpful. Oh my gosh.
All righty.
Alrighty, so Section 27, when Merv's PowerPoint starts working, there we go. Okay, awesome. So Section 27 is the first way in which we can enforce a maintenance order. Now, Section 27 deals with a warrant of execution. I'm sure some of us have heard this term. Some of us maybe have been victims of warrant of executions. I don't know, but let me explain to you what it means, okay? So warrants of execution in layman terms is the attachments, particularly set out in the Maintenance Act, right? It deals with the attachments of movable property. So these are things such as vehicles, I don't know, if you have expensive paintings, that type of stuff, right? Movable property. So not your actual house and, you know, things that you really can't move around, like a property. So it's movable property. That's very important to note, okay? So what will happen is if the person is owing you money, you will go to court and you'll say, I want a warrant of execution set out. Well, then, if you have attorneys, they'll draft the warrants of execution for you. If not, the clerks at the maintenance court will assist you with that, where they draft a warrant of execution for you to say, this is the amount that is owing to me. The person who I'm claiming the amount against has 2 vehicles to the value of 100,000 Rand, okay? So if they owe you 50,000 Rand, they've got 2 vehicles worth 100,000 Rand, 1 vehicle's worth 50K, the other vehicle's worth 50K. The maintenance officer in the warrant of execution will explain to the sheriff, who's the person who will generally carry out the warrant of execution, please attach that guy's first red vehicle, it's worth 50K. We want to attach that property, so you need to go to his house, you need to take the car from him. So they'll first do an inventory. They'll go to the person's house, the respondent's house, the person who's owing the money. They'll look, what are the things that the person has at their house? What assets, movable assets do they have? So if they notice the red vehicle, they'll have it valued. If it's valued at 50K, they'll say, cool, we're coming back. So if you don't pay the 50K, we're coming back for your red vehicle. They'll literally come with the tow truck driver, pull your vehicle out of the yard, take it, sell it on auction, and pay your wife or whoever you owe the money to the 50,000. So it's very embarrassing, warrants of execution. I'm never a fan of them, but I mean, you need to do what you need to do for your client, right? So that is essentially how a warrant of execution works, practically speaking, right? The Act just tells us that it can be enforceable, it must be brought in the prescribed manner. That really doesn't give us any details. Practically, you kind of need to know how it works. Now, important to note with the warrant of execution is that it can also be set aside by the maintenance court. So once you've complied with the order, if they've sold your vehicle now and you've paid the 50K that was outstanding based on the proceeds of the sale, the maintenance court, if you apply to them, they can set that order aside. So it's fine, at least once everything is sorted, you can have it set aside so it's no longer against your name, if I can put it like that. Now, the next option that we have to obviously enforce a maintenance order is dealt with in terms of Section 28, which deals with an emolument attachments order. Now, people always confuse this with, like, does this mean a garnishee order? What is emoluments? What does it deal with? It's so complex. And again, the Maintenance Act, respectfully, it's really not for a layperson to understand unless you know the process. Practically speaking, it really doesn't give you any answers. Now, when we speak of emoluments, we're speaking or referring to salary or wages. So what are the earnings of a person? Okay. Now, generally what happens here is if the person, say a person owes you, I had a client, right? And the husband owed, in terms of the divorce order, the husband was in arrears of, I think, approximately 60,000 Rand maintenance. What we did is we fill out again, you go to court, you explain to them the process. They'll ask you, is the respondent employed? Is he self-employed? Because that will depend on the type of application that they give you. So if he's employed, they'll explain to you, okay, fill out his employer's details. Where is he employed? What does he do? How much does he earn? Do you know where his business address is? During COVID, it became a challenge because everyone started working from home. Now you're just like, we don't know where this guy lives. We know he's employed at this big place in a big firm in town, but where do we deliver the order? Because if we get an order, where do we deliver it so that he's actually aware of it? So what you'll do is you'll go to the maintenance court, you'll explain to them, respondent is employed, this is where he's employed, this is his job title, this is how much he earns a month, this is how much money he's owing me. You'll then fill out a form that they'll then submit to the magistrates for consideration. What I found during COVID is they were not even holding a trial or giving the respondents a chance to come to court to explain why they're in arrears. The maintenance magistrates in Ridderput were literally granting these orders in chambers. So you deliver your application, you go back in about a week's time, order granted, magistrate heard it in chambers. Get the order, that's great, because now no one is fighting. We've got the order, let's just enforce it. So if you get an emolument attachment order, what it means is you need to provide this order to the respondent's employer. So if they work, for example, for the Department of Health, you'll submit it to the HR department for the Department of Health, which is complex because you don't really know who in this huge HR department you submit this order to. But you submit it nonetheless, and you instruct them in terms of the order that they need to deduct money from this person's salary before they receive their salary to satisfy the maintenance that they're owing. People get very cross with this order because they're like, I don't even have the 3,000 Rand that you're deducting. And I'm like, well, the kids need the 3,000 Rand, so I don't really know what you want me to do about it. You can go to court and you can explain to the court that you're unhappy, but this is where we're at. So that's how the emoluments attachments order works. It's important to note here that they'll do it on a monthly installment. They'll ask you to repay the money that you're owing in a monthly installment. So they won't take, if your salary is worth 60K, they won't take 60K, your entire salary that month. They'll say it must be paid off, for example, in installments of 4 grand a month, whatever is reasonably workable, not only for the applicant, but also for the respondent with their own expenses that they would have. Now, again, with such an order, you can also, once you've paid the maintenance in full, you can go to the court and say, I'm done paying, please can you set this order aside so they stop taking my salary. But I would always advise you guys, until that money is paid in full, do not agree for the order to be set aside. The person I got an emoluments attachment order against was begging and pleading, can he please set this order aside, he'll pay the maintenance. And I'm like, sorry, my friend, you didn't ever pay the maintenance. This is why we're at court. So until your maintenance arrears is paid in full, you're welcome to approach the court if you're unhappy. Now, when we look at a garnishee order, I was saying to you guys that people often confuse an emoluments attachment order with a garnishee order, okay? Interesting enough, a garnishee order deals with an order of court for the attachment of debt by other means than a salary or a wage to recover payments. Okay, so that's just a side note, something interesting if you guys wanted to know the difference. I found it very interesting. So then if we look at section 29, Murph, before we move to section 30, I just want to go into section 29 of the Act, which deals with the notice relating to emoluments attachments order. I briefly touched on it when I was explaining to you guys with the process you follow if you get an emoluments attachment order. But essentially what happens, if you get an emoluments attachment order granted by the magistrate, what you need to do to give effect to the order, so you can't just get the order from court and then expect the money to be paid, right? You need to be proactive. You need to take further steps. To give effect to this order, the maintenance officer, okay, will within 7 days after the day on which the order was made, cause a notice to be served on the employer. Now, please, this is South Africa. The maintenance officer is not going to do this. You need to go to court. You need to ask for that order. And within 7 days, this is the catcher. You've got 7 days within which to give that notice to the employer so that they can take effect for the next month's salary as soon as the salary run happens. You also need to be mindful that some companies pay on the 15th of the month. Other companies pay at the end of the month. So you really need to be clever as to how you get that order to the employer. And bear in mind, the biggest catcher here, it's got to be within 7 days. Otherwise, you've got problems. So just be mindful of that, okay? Then, section 30, which deals with an attachment of debts, okay? Now, this is an order that allows a person to recover money from a third party. So if dad is owing, and I'm not making this sexist, right? It's just an example. If dad is owing arrear maintenance and we know that there's a friend that he's owing money to, or someone owes money to dad, right? For example, so dad owes you money, but someone is owing dad money, and you have knowledge that this person is going to be paying dad the loan back that they owe dad of, say, 30,000 Rand, and your maintenance owing is 10,000 Rand. You can go to court very cleverly and very carefully and cautiously and ask for an order that the person who owes dad money, okay, before they pay him the full 30,000 Rand, they pay you your 10,000 Rand, which dad owes you, and dad will then get the balance of the 20 that's owing to him. So it's not an order I see very often because people aren't aware that this is a step that they can take. I've never done one of this nature myself, but it is an order or a remedy available to you in terms of Section 30 of the Maintenance Act. So I think that would explain that one. And then again, an order of this nature can also, on good cause, if the maintenance arrears or whatever has been settled in full, it can be suspended, amended, or rescinded, obviously on application to the court. Okay, and you would need to show maintenance has been paid in full now. Please can you rescind this order so that I can actually get money back that's owing to me and my wife stops taking it for the maintenance I was owing to her. Now, the next section that I want to deal with, Merv, I'm just going to move on to Section 31 first. I see you've got your Sequestration, Insolvency Act, etc. We'll come back to that. Section 31, okay, which deals with offences for maintenance orders. Now, it's always nice if someone is giving you the runaround for maintenance that they owe to just quote the section in your letter to help them understand that we are not playing. If we get an order against you, and you are going to default on your order, these are the consequences. So what are the actual criminal offenses that can happen to someone or that someone can get if they fail to pay a maintenance order and they fail to remedy paying the maintenance? So the first thing is a fine, okay? The magistrate really has the discretion here to determine how much that fine is going to be. So if you've got a very angry magistrate, they can order, I think, like $2,000. It's really dependent on the magistrate dealing with the matter. The second thing that can happen is you can get imprisonment for a period not exceeding 1 year. Now, generally, when you tell people this, they start panicking. They think we're going to the chookies. This is not cool. I'll pay you the maintenance that I owe you. So you just quickly quote that section and you'd be like, this is what can happen to you. Please can my client have her maintenance arrears? So obviously, if we go with the option of an imprisonment for a period of not 1 year, it can also be that you get imprisonment with the option of a fine. So again, it's really dependent on the magistrate and what order they want to make, but this is really criminal proceedings now. It's no longer in the civil maintenance court. It can obviously still be heard before a maintenance magistrate, but it's really criminal proceedings now, and it's a very serious process. At the end of the day, if you get to this point, you kind of need to know that you've got trouble. Now, with defenses raised, obviously in criminal proceedings, there are defenses that get raised. In this particular matter where there's money owing for a maintenance order, okay, if the defense is raised, so if they're accused, so if mom's the one that's owing maintenance, if mom is the accused person and she raised the defense that she didn't adhere to the maintenance order because of a lack of means, okay, just because she says that, it doesn't mean that she'll get acquitted. The magistrates don't really function like that. They're not just going to say, oh, shame, she didn't have money. It's okay, you'll get acquitted. It doesn't work like that. Firstly, they'll explain to you that you had a remedy in terms of the Maintenance Act to come and tell us that your circumstances have changed. You need to decrease the amounts of money that you were supposed to pay because you've either lost your job, you've had a salary cut, which we saw very often in COVID. So just because you say, I failed to pay the maintenance because of a lack of means, doesn't mean you will get acquitted. So what will happen here is it will have to be proved. If the court proves, and there's a good attorney on brief, and the attorney proves that the failure was due to your unwillingness to work, okay, or misconduct, because that often happens. People just give up their job so that they can stop paying maintenance. Just because you do that, it doesn't mean that you're clever and that you're going to get away with it. You'll have to show the court that I was actively seeking employment when I lost my job. I'm still looking for the job. I don't have any means to pay the maintenance. So if the court finds that your lack of means was also due to unwillingness to work or misconduct on your part, you will possibly get a fine or, again, imprisonment not exceeding 1 year. Now, a person who's been convicted, right, in terms of this process, so if they find you guilty and they, obviously convict you of an offense under the section, the maintenance officer can furnish particulars, your personal particulars, to companies to basically blacklist you. So it will affect your credit rating. It's got major implications for you. When you want to go get a cell phone contract, they're going to say, no, sir, there was this maintenance order granted. We see here that you've been flagged. You're blacklisted, can't help you. So you really need to explain to the clients, especially people who are defaulting on their maintenance payments, it's not a joke. You need to take it seriously. And please approach the court. You've got the relief. If you can't afford the maintenance that your wife is asking for, go to court, tell them these are the means. I can't pay you 2,000 Rand if I'm earning 1,000 Rand. It literally doesn't work like that. You can't take water out of a stone. So you have those remedies available, but it's very important that you explain the criminal aspects of the maintenance proceedings to them. Something people don't actually know about. Now, just going back to the slides, you'll see Merv mentioned, I'm just waiting for his slides open. Merv mentioned a case law here that's a case, it's SJ versus JHA, okay? So this was a very recent matter that was decided. It's a Western Cape Division judgment. Now, I just want to go into, I'll tell you there what it says on the slide, but I want to just get into a basic background of the matter just so you can understand it. So it says here, maintenance orders are civil judgments which stand until set aside or varied by a competent court. They are enforceable for 30 years from date of the court order. Now, I think this is a bizarre judgment that happened. I honestly think it's going to change the maintenance game completely. But essentially what happened here, right, is the first respondent in this matter, and if you guys need a copy of the act, please let us know so that we can either paste it in the chat box or we can email it to you. Now, the facts of this matter is that the first respondent caused a writ of execution to be issued against the application in terms of a rear maintenance dating back to July 1993. Now, that's like 28 years ago. That is crazy. I'd have been like, that's too long ago. Please just leave me alone so that we can live our lives. Now, what had happened is that the writ was stayed pending these current proceedings in the Western Cape Division, okay? The applicant challenged the validity of the writ on the basis that the maintenance claim had prescribed. So essentially, the applicant is saying, well, this order was granted in 1993. Firstly, that's like even 28 years ago. How can this person still come and be claiming stuff from me? This is bizarre, okay? Now, the biggest issue in this matter that the court had to deal with was whether an undertaking to pay maintenance in a consent paper, so in a settlement agreement, incorporated into a divorce order, given that the order did not have the character of a final judgment, was a judgment debt prescribing after 30 years or any normal debt prescribing after 3 years. Okay, so this was really the big question in this matter. Now, the courts held that the settlement agreement, I'll say consent paper, but settlement agreement, which was made in order of court, must be construed as a judgment of the courts, and as such, it was a judgment debt. What does this mean? Judgment debt being a debt prescribing after 30 years. Therefore, the court held that the 30-year prescription period applied. So what did this mean for the applicant is that, my friend, there were 2 more years left before this judgment prescribed. So this person is well within their means to be before the court and to apply if you've obviously failed to pay the maintenance. Now, the maintenance order formed part of a consent order and should be treated no differently to any other part of the order. This is what the court held in this matter. Essentially, the court decided that the maintenance order that was granted back then in July 1993 was final and enforceable until varied or cancelled. So essentially, again, the 30-year period applied and the maintenance order must be carried out immediately. Now, when I read this judgment, I was like, that's bizarre, because I would think if you've divorced someone like 10 years ago, you're kind of free and you can live your life. But it doesn't appear this way. A maintenance order will be considered a judgment debt, which only prescribes after 30 years. So please, for 30 years, do not breathe, pay your maintenance. And if you don't do that and after 30 years your ex-spouse can't find you, that's great. Then at least you're scot-free on that one. But please be careful in that regard. Merv, if we can go to the next slide.
Lee,
Yes.
In terms of the slides, but this sequestration issue, I think just alert everyone to AR versus HR. You can get sequestrated for arrear maintenance, very important. And then we'll just go on to the international framework, which I'll tackle. And then you can breathe finally.
So
Please,
just briefly in terms just briefly in terms of what you were saying there with the Insolvency Act, obviously, yes, as Murph mentioned, you can get sequestrated with the maintenance court order. So just because it's in a magistrate court, it doesn't mean that this order isn't powerful. But it's also important that people obviously sometimes declare they're like, I'm insolvent, I can't afford to pay my maintenance. Bear in mind that the maintenance court doesn't just take that statement on face value. There'll have to be a full investigation done. If you were declared insolvent, they'll have to obviously have a copy of a court order and then decide on what the next steps are to give the applicant relief who's claiming maintenance from you. So for those of you who have Dodge clients, please don't tell them, or if they say, I'm going to declare myself insolvent so she can leave me alone, please just advise them that it's not just going to be taken on face value, such a statement. The court will investigate into this. They'll hold a full financial inquiry before just deciding whether or not you being declared insolvent kind of frees you from your duty to pay maintenance. So yeah, just be careful.
Just be careful in general.
No, exactly.
Lee, thank you so much. Guys, can I ask, do you have any questions for Lee based on her section, or shall we finish up and raise some more questions at the end? Lee, I want to actually, I'm going to argue with you a bit on this SA versus JHA. Isn't it good that judgments have teeth?
No, I definitely think it is, Murph. That's what I'm saying. You know, people have the idea, oh, we divorced 10 years ago. I stopped paying 7 years ago. She's quiet now. I'm sure I'm scot-free. But I think this judgment is going to open the eyes of a lot of people who are in default, willful defaults with their maintenance orders. And I think it's also going to save a lot of people. I mean, 30 years is a long time. Some people get divorced. We're seeing it now, generally between the ages of 35 and above. So if your maintenance order is in place and you got divorced at 35, it's generally going to run till about 65, which gives you enough time to get money out of this person until you can obtain your own retirement money. So I think it's brilliant. Yeah.
Yeah, look, I think it seems quite harsh. I mean, 28 years on, but for those who are interested in reading the case, we will obviously share it.
Yeah.
What's very, very interesting from this case, and a very nice quote from the judge, is the judge kind of made it clear to say, you know, just bear in mind, the judgment debtor is not the victim here.
Yeah.
The judgment creditor is the one who's actually been sitting for 30 years, actually having to sien kom klaar, as we say in Afrikaans. And, you know, it seems harsh because these things can very easily blow up. I mean, if one looks at, for example, a 6-year-old child and a maintenance order is made till age of majority, for example, you've got 12 years. So 12 times 12 is 144 months at the end of the day. And let's say, for example, that you are ordered to pay 5,000 Rand a month. That gets up to 720,000 Rand. It really, really goes. And one is tempted to feel sorry for these people. But guys, I do want to just alert you, and Lee also made the point earlier very succinctly, it is then that person's, plus interest, am I absolutely? Yeah. It is that person's responsibility to approach the court for a discharge or for a variation. And too often what happens is people just don't pay. Then they get dragged to an enforcement court, let's say on a section 31. It gets converted into a section 10, and the thinking is, yeah, well, we're just going to give a new order. But what about the years that they are in arrears? So don't forget about that. Mediators as well, obviously, practical solutions, but just bear in mind, the judgment debtor is not the victim. They are the offender. the person who bona fide needs the money and didn't get it is actually the victim in a lot of cases.
Just to add on to what you're saying, you know, I had a matter, and I was so grateful for this maintenance officer having some sensible thinking going on here, because that's very rare. In the matter where I had obtained a garnishee order against this guy that's employed in a big firm in Joburg, essentially when we got to court, he then tried to launch a counter application for a variation of the maintenance order to basically decrease the maintenance that he had to pay. And the maintenance officer turned around and said to him, I'm not going to entertain your application. You've been in default for approximately a year, and you failed to approach the courts any earlier than now when we obtained a garnishee order against you. So until your arrears is paid in full, I will not entertain any decrease application in this court. You can come back when your arrears is paid in full, then we can have a discussion. So I think those hard decisions being made by the maintenance officers and the maintenance court is really what's going to assist people who are in honestly horrendous situations with arrears maintenance. Yeah, I think it's needed. It really is needed.
Absolutely awesome. Lee, thank you so much. Excellent, excellent. I appreciate it. Yes, Alfred.
Sorry to interrupt you again. As I said, my hands up is not working.
No.
I just wanted to, from a mediator's point of view, and I think it's really, really important that us as mediators understand that we have a very important or a dual role to play, not only to get to a finality as far as maintenance goes, but we should educate the clients, and unlike the legal profession, where the legal profession works in black and white, we can be more creative, and we can do lots of other different things when it comes to settlement agreement. And when I say educate the clients that this is not money that's for the soon to be ex-spouse, this is money for the children. And it's very important that we play on that sympathy or empathy card, and I think that it means that people will pay a lot more easily if they understand where their money is going to. And again, the other thing is that's why they changed the word maintenance to contribution, because it's not maintenance anymore. It's a contribution towards your children's upbringing and their future.
Yeah, absolutely, absolutely. Very, very well said, Alfred. I agree with you 100%. You know, maintenance, especially child maintenance, it's the right of the children and not necessarily of the parents. And, you know, I had a discussion with a Silk a while back on a matter where my client said, you know, let's just write it off for the sake of moving forward. And the Silk and I discussed this, and the position was kind of to say, but can she really do it? Is it her place to say that these additional means, which she would have had at her disposal to give these children a better life, can she actually just say, you know, forget it? Look, obviously, where does one draw the line? I want to quickly just touch on one or two of the things raised in the comments, and then I'm going to go on to international maintenance frameworks very briefly. Mariki, obviously you raised estate surrender. Now, guys, just understand in terms of sequestration, either voluntary or if the actual creditor raises it, remember the requirement to show that there will be a benefit to creditors. Very, very important. But this is an interesting one. You know, the case law seems to really favor it. People are getting sequestrated. Rickmar says 100% agree, child maintenance for the child to forego, not the parent. Absolutely. I suppose, you know, if one considers the role of a guardian to assist the child in administrative and legal affairs, technically, I suppose the parent can, but from an ethical point of view, I don't think it's for a parent to say, you know, you owe me $100,000. Let's just let it go for maintaining the peace. That 100,000 could be the first 2 years of varsity, which could give this child a better life going forward. So Lee, yeah, thank you so much for your section on what actually happens in court. You know, it's wonderful to talk about what the act says should happen, but it's not always what happens. Guys, I'm going to give 2 minutes. Speak now, forever hold your peace. In terms of questions, comments, queries, please feel free to put up your hand or type in the comment box furiously. And then we'll go on to international. Okay, Mariki says, LOL TV that costs 20,000 Rand, that will have to be investigated. Absolutely. Renal says, so if children are over 18 and self-sustained, the father needs to go to court to suspend the maintenance. They can't just stop it. If there was a maintenance order, the maintenance order would generally say until when it would be applicable. But remember, the duty to pay maintenance does not necessarily only flow from the maintenance order. I hope that answers your question. If not, Renal, get in touch with me and I'm happy to discuss. Mariki, your hand is up. How can I help? Or how can Lee help? Give her a doozy. Make it nice and difficult on a Friday.
Shall I go for insolvencies then? I just want to find out, how often do you have these estate surrenders and sequestrations with the cases?
The most, I haven't dealt with one personally, I'll be frank with you. I've seen it in the law reports. I'm aware of 3 or 4 cases, and it wasn't a surrender, it was a creditor's spouse.
Oh, they do it voluntary.
Sorry?
They do it as friendlies. You get...
No. This case law specifically, this AR versus HR, was an opposed matter where the spouse that had the maintenance duty and the order against them actually opposed it and said, no, I don't want to be sequestrated. I haven't seen a reported case for a friendly. Conceivably, I suppose you could do it as a friendly, but I'm not 100% sure, hey?
They make the, what's vijandig in Engels? The opposed ones. They make them, of the friendly ones, they make them look like opposed ones.
Oh, really?
Yes.
I've dealt with a counsel that was acting on one of these opposed ones, and I don't think that he would do a friendly one.
These massive fights they're putting up, and it's all just show. I know, because this is what I actually do for a living.
Awesome. Mariki, thank you so much. I'd love to have a coffee with you and get all the dirt. Where are you based?
I'm in Bloemfontein, but the internet's everywhere.
Internet's everywhere. We're going to do a lekker virtual coffee, and you're going to tell me all about it.
I would love to. I would love to see how long Lee can hold the breath, though.
Absolutely. You know, my favorite thing about Bloemfontein is if you look at the courtyard of the SCA, there's a braai standing there, and it's the most beautiful Bloemfontein thing I've ever seen. You have this big fancy building and the braai outside. I love it.
You have to braai on a Friday.
You have to braai on a Friday, even the judges in all of their robes. Mariki, thanks for your input. Appreciate it. Guys, I want to quickly look at international enforcement, and it's a problematic thing, and I know we're running out of time, but it bears talking about. And Barbara, thank you so much. I think it was one of your questions. Oh, no, it wasn't Barbara who raised the question. In any event, someone raised the question, what if someone is in the UK? How do you deal with it? And I did some digging, and incidentally, we have an act that deals with it, which is the Reciprocal Enforcement of Maintenance Orders Act 80 of 1963. From what I can see, it has not yet been repealed, and it provides in 2 sections, very, very interestingly, how to deal with these types of matters. Now, a huge, big, fat caveat I'm going to put on this: be aware that just because the Act says this does not mean that's what's going to happen in practice. Let's take notes from what Lee has said earlier in terms of what the law says and what happens in practice. But in any event, Section 7 says that whenever it appears to any court in the Republic that a person against whom it has, before or after the commencement of the Act, made a maintenance order is resident in a proclaimed country, and this is very important, we'll look at proclaimed countries shortly, the court shall transmit to the minister comes there, a certified copy of the order for transmission through diplomatic channels to an authority of such country recognized for the purpose by the minister. Now, theoretically, what happens, if I can sketch it to you in your mind's eye, you have country A, which is South Africa. Mom is living here with the kids. She has a maintenance order against dad, who is living in country B. Mom would then approach the maintenance court. With the order, the maintenance court would approach the minister would approach the relevant authority in country B, and country B would then execute it. Once again, I'm sure most of us in the olden days had played broken telephone. So you can imagine the broken telephone effect with this, but this is the legislative framework. Then the process, very interestingly, for bringing a maintenance application against someone in a proclaimed territory. In terms of Section 8 of the Reciprocal Enforcement of Maintenance Orders Act, you can approach the court, and from what I could see, it is a normal application in terms of the prescribed form, which is in terms of the Maintenance Act. You're welcome to Google it, but we will also distribute it. It's the form J101, it's the application for a maintenance order. The court can make an inquiry in the absence of the person who's in the proclaimed country, because obviously they wouldn't be served in South Africa with this application. So the court can then make an order, but it can only make a provisional maintenance order against the person in the foreign territory. That then goes a certified copy with the witness statements and the records, etc., will then be given to the relevant authority in the foreign jurisdiction, who would then serve it on the person against whom the order has been made. Can I ask to our attorneys in the House, have any of you dealt with one of these before?
Mervyn?
Yes, Alfred.
Sorry to interrupt again without raising my hand once again. I dealt with something like this many years back as a mediator, and what we had to do was get a mirror order in the country where the person resided. What the legal guys had to do was we had the order here in South Africa, but to enforce it, they had to do a mirror order overseas in order to get that enforced, just as a matter of by the by.
Interesting. Which jurisdiction was it? Which country?
If I remember correctly, and as I said, it was very many years ago, it was the UK.
Yep. Okay. That's the one we tend to see the most, hey, is the UK. That was the question as well that was raised in the intake form. Yes, Rikma.
Hi, Mervyn. So I've sort of dealt with residuals of this type of matter, but I haven't done one myself. But my understanding after chatting to counsel is if the parties are, or if the country where the person responsible to pay maintenance is a proclaimed country, i.e. a signatory to the Reciprocal Enforcement of Maintenance Act, then all you need to do, so it's automatically recognized, you send it to the authorities, and it can be enforced there and then by that authority in that country. If it's not a proclaimed country, then one would have to do a mirror order. So the process would essentially be to have it apostilled and then to send it to a correspondent attorney in the foreign country and for them to bring an application. Yeah,
that's my understanding of it as well. And guys, as a nice reference, this is the list of countries with whom we have reciprocal enforcement agreements, the most recent published one that I was able to find. So we've got Australia with its various territories, Botswana, Canada, the Coco Islands, Cyprus, Fiji, Germany, Guernsey, Hong Kong, Isle of Jersey, Isle of Man, Kenya, Lesotho, Malawi, Mauritius, Namibia, New Zealand, Nigeria, Norfolk Islands, Sarawak, Singapore, St. Helena, Swaziland, UK, which obviously includes England, Northern Ireland, Scotland, and Wales, the US, but only California and Florida, Zambia, and Zimbabwe. These are the countries with whom we have reciprocal enforcement agreements as published by the department. I'm not sure whether any new ones have been gazetted. Rikma, do you perhaps have an updated list?
Mervyn, I think your list is accurate. I don't see any outstanding countries now. Unfortunately, if we can just get Dubai on there, I would be so happy. Or
Dubai,
India.
or Qatar, or UAE, UAE, all of those. Those are difficult ones. All of the traditional Sharia countries are very tricky.
I think my respondents are all fleeing to those countries, full well knowing that I have difficulty touching them. So yeah.
Going the way of the Guptas.
Gosh.
Thanks, Rikma. And then in closing, guys, Rule 43, Rule 58. It's our interim maintenance matters. I'm not going to go into a heck of a lot of detail with them. We do know that you can get an application for maintenance on the planks for under Rule 43 in the High Court, Rule 58 in the Marriage Court. Maintenance pendente contribution towards costs, interim care of any child, interim contact with any child. And then obviously, guys, we've got the FDF. Can I just have, by show of hands, has anyone not learned about the FDF by now? Then I'll quickly go through it. Otherwise, I take it that everyone is aware of it. Right, Khadija, all right. Have you got a question? Would you like me to go through the FDF quickly? Fantastic. Okay, well, awesome. Let me quickly go through it. The Judge President for the Gauteng Division of the High Court, now very important, guys, this is the Gauteng Division, made the directive of February 2020, where they postulated a financial disclosure form or a financial disclosure affidavit, which I will show you briefly. It has not yet, to my knowledge, caught on very much in some of the other jurisdictions, but in Gauteng we are using it and it works a treat. I'll just share it with you. I will distribute it with our course pack, or Lee will distribute it when she gets in touch with all of you. It basically looks like this. It's a form under oath where you give information, general information regarding yourself, details of the children, details of any pending court cases. Then you go through your financial position, immovable properties, you go through investments, accounts, pension interest, money that's owed to you, and. Then you would go through liabilities, you would go through directorships in companies, you would go through your pension interests once again, you would go through other assets, share options, offshore investments, etc., etc. And then you would go through your income and expenses. And it really is a very, very thorough form, which is nice for parties to fill in. I found it a very, very nice tool for arranging roundtables with opposing attorneys and what's nice is they, in the prescribed form, Alfred, if you'll just let me finish with this, then you can jump in. They actually put a nice paragraph here. If you're found to have been deliberately untruthful, criminal proceedings may be brought against you. This is the prescribed form from the Judge President's directive. It works beautifully for financial disclosure. I will share it with everyone, even those in different jurisdictions outside of Johannesburg. Be aware that it exists. Work through it. It might be worth something to you in your practice. Yes, Alfred.
Hi, Mervyn. Sorry, that's the greatest tool that they've come up with as a mediator. I'll tell you, I included with when the first session with the mediation, and people just turn white when they see that, and suddenly they start disclosing things that they would never disclose, and it alleviates a lot of pressure on me to start, probing and researching people's backgrounds. Wonderful tool as a mediator.
Absolutely, and because it's kind of rubber stamped by the courts, for attorneys in Joburg and Pretoria, it's so beautiful because we say to the parties, Guys, you're going to have to do it in any event. The directive says you've got to do it. So let's disclose. Rikma, do you guys have anything like that in the Cape at the moment?
Between sort of colleagues, we tend to use that document. Mostly I have, my clients fill it out, and I use that to brief counsel when drafting the sworn statement. But no, not my understanding is that we don't have something like that. We kind of just wing it.
Yeah, but you're winging it correctly. It's a beautiful form. I love it. I see Khadija, Corinne, your hands are still up. Any questions, or was it just to go through the FDF? All right. Okay, any questions on the FDF? I see Corinne, your hand is down. Khadija, anything from your side? You're still muted. All right, no questions on the FDF. Anyone else have any questions on the FDF? Questions, comments, queries? I think the overriding opinion is the FDF is a good thing rather than a bad thing. Guys, that's our that's our material for this webinar. From my side, from Lee's side, thank you so much for taking the time and joining us for this. We're obviously going to go into some Q&A and discussion, and I encourage you guys to stick around with us while we do it. For those who are not able to stay in with us while we go through it, we completely understand, and thank you so much for joining us. We finished with 4 minutes to spare.